Okay, Ms. Corrigan, you're up.
May it please the court. I'm Jody Corrigan with Rock, McLean, and Sabar, and we represent the appellants, the non-resident defendants, Level 8 Management and Pierre Accounting. I'd like to reserve 5 minutes for rebuttal.
Sure.
The trial court basically misapplied the court's decisions in the Capella RJPT case and the Stone Peak Partners case. If this decision is allowed to stand, it stretches the concept of limited jurisdiction over non-resident defendants and violates due process. What is peculiar about this case and why what sets it apart from all of the others, at least that I found, was that the only connection to Florida is that the plaintiff, Wildflower, was registered as a Florida LLC. While it was formed in 2017 by filing articles of organization in Florida, when the parties worked together, even Wildflower was not operating in Florida. Since 2018, Wildflower's principal place of business has been Texas. Greg Wilder, the principal of Wildflower, and he's the owner and also the manager of the LLC, his address is in Texas, not Florida, and he has not lived in Florida since 2017. So Wildflower, the plaintiff, had no Florida office, no Florida employees, and for the work that the parties performed together, there were no Florida clients and there was no revenue generated from Florida. In a nutshell, the trial court's ruling hinges on the fact that the judge determined that the parties operated as a partnership, and because Wildflower was a registered Florida LLC, that alone was sufficient to confer jurisdiction in Florida. The trial court's decision—
If I may, Ms. Corrigan, let's just jump to what I think is the crux of this matter, the connexity issue in this matter.
Exactly.
Because I know the Capella case, we talked about the Capella case, which I happen to author, as you know. It dealt with a business venture, and what made it unique, it's basically came to the conclusion that certain investment money that was being flooded into LSI, that was enough of a connection to subject the folks to the personal jurisdiction. So I know there's a much argument about whether or not this was a partnership or business venture. Let's step that aside for a moment. Let's focus on the connexity aspect here. And I have pulled up the trial court's order. And as you know, as a background, any factual determination, unless it is clearly not based on substantial competence, and we have to defer to the trial court. Let's go through that and let's see what connexity is there in this matter.
That's one of the largest problems in this case, is there really is no connexity. What happened was the trial court focused its decision on the plaintiff's actual connections to the state. And the plaintiffs argued that it was operating in Florida, even though the facts, as they're laid out in the briefs, demonstrate that there were no Florida employees, there was no actual office in Florida, there was no money derived in Florida, and there were no clients in Florida, even though there were 50 clients. For connexity purposes, the court simply stated that there was a causal connection between the defendant's activities in Florida and the plaintiff's cause of action, but it did not cite any specific activities. And when you look at the activities, this is very unlike the RJPT case. We were also involved in that case. Here, the defendants didn't take any actions to Florida. Unlike RJPT, RJPT was the Texas company. It came to Florida to invest in LSI, which was a Florida company.
Ms. Corrigan, you would agree that you don't necessarily need an office to conduct business in Florida. I think the cases are pretty clear on that. The trial court did also rely on the fact that there's an arbitration clause in the engagement letters with the clients, and that certainly, assuming for the sake of my argument and question here, that the partners knew that at some point, if they were to have to litigate any issues with their clients, that they would be hailed into court in Florida. Why is that not sufficient contacts under our Florida long-arm statute?
There's a few reasons why that agreement is not the operative term. This is not a lawsuit over any violation of the agreement. The agreement, and Mr. Wilder himself admitted this, the agreement was something that bound the clients to the agreement. So if there was a dispute with the client, then those matters would be arbitrated. And it wasn't subject solely to Florida jurisdiction. It was Florida or Texas jurisdiction. So that decision as to whether Florida would even apply, even in that context, was not clear from just the terms of the agreement itself. Also, the agreement itself also had the statements in it that it wasn't creating a partnership, and that also answers that question of as to whether there was a partnership. So that's not the binding. Go ahead.
Does it not matter as well that we have a Florida attorney here that is giving some advice, and that it could have reasonably been expected by the partners that, giving that advice and, while operating in Florida? I mean, is that similar to the Vernon case where you have non-residents who are working on cases in a probate case that is in Florida, one of the Florida courts, where you have a partner of and assume for my sake of argument that this is a partnership and that we did find a partnership where you have one partner giving advice from Florida.
The difference between the Vernon case and this case is here the quote Florida partner wasn't actually operating in Florida. And the fact that he was a licensed Florida lawyer, what was important for the operation of the business that the parties were conducting together was the fact that he was a lawyer. It did not necessarily require Florida law. This was a federal tax credit that they were applying for. So the fact that it was a Florida lawyer, it could have easily been a Texas lawyer. It could have been a lawyer from anywhere. But
were any of the other partners lawyers to give legal advice?
No, they were not.
So does that fact matter?
Does it matter that they were not lawyers?
Well, right. I mean, here you have, if someone is giving legal advice, giving and contributing that to the partnership, does that matter?
I don't think it matters that he was a Florida licensed lawyer. It matters that he was a lawyer because he was providing that skill to the partnership, but it does not matter that he was licensed in Florida because, as the facts demonstrate, he still wasn't, he wasn't operating out of Florida. And unlike the Vernon case, this was a partnership that involved, it had a Florida office and it had a New York office. That is not the case here. It's kind of what also brings up that the Kelly versus Department of Insurance case, that was a national partnership. It was a big 8 accounting firm. I believe it was Tooth Ross. And therefore that they found that the non-resident accounting partners were subject to jurisdiction in Florida because the work that was being performed, the accounting services that led to the malpractice claim, came out of the Florida office. And the Vernon case, it was the out-of-state lawyer, the New York lawyers, that were actually helping litigate the probate case in Florida. This case does not have that connection. Here, as I mentioned, what the trial court focused on here was establishing the plaintiff's connections to Florida and not the defendant's connections to Florida. And if you go back to, the partnership itself, even if there had been a partnership, you need to have more than the residence of one of the employees or one of the parties, excuse me, you need to have more than that to establish jurisdiction. That was the Rapopon case out of the 4th District. The Sutton case said the critical factor that gives rise to jurisdiction is that a partnership must have contemplated and involved performance in Florida. And here there was neither. Because Mr. Wilder himself was operating out of Texas, the parties, even if it was a partnership, couldn't have anticipated that the work would be being performed in Florida. And as the record shows, it wasn't being performed in Florida. There were 50 clients of this arrangement of the parties. They were out of 15 different states, but not one was in Florida. There wasn't a Florida client. There wasn't any Florida revenue generated.
But wasn't there testimony though from Mr. Wilder that he was trying to solicit Florida clients? And I think there's also testimony that the trial court, that we must defer to the trial court's findings, that found that Mr. Pierre was in Florida for a meeting that had to do with Wildflower business.
Yes,
correct.
And you do have to defer to the trial court's credibility determinations. And Mr. Pierre did go to Florida once. It was disputed what the purpose of that meeting was, but irrespective of that, it was only once. And that doesn't address level 8's participation in this. Level 8, no person came to Florida ever. They were the party in the group that was solely operating in California. They never went to Florida. And Mr. Pierre's one-time visit to Florida is insufficient, candidly, to create the causal connection, because the creation here, what we need to connect to is the defendant's activities in Florida, not the plaintiff's activities, the defendant. And that connection to the actual cause of actions that are alleged. Here, Wildflower is attempting to recover professional fees that it claimed is owed as a result of the party's relationship. But those fees were not generated from Florida clients. So even what it is seeking to recover does not have any relation to the state of Florida. And the problem is that Mr. Pierre went to Florida once, but this is unlike the RJPT case. The principal of RJPT came to Florida, met with board members, inspected facilities, and then voluntarily entered into an agreement with LSI, the Florida company. Unlike the contract in this case that applied to the clients, the contract that RJPT signed up to purchase its interest in LSI actually did compel that party, the company RJPT, to have venue in Florida. The RJPT case is also different because the RJPT spent, I think it was a 6-year time period where it bought and sold interests. It eventually earned about $18 million. It received 35 distributions from Florida. Its activities were much more connected to Florida. What we have here is Mr. Pierre came to Florida once. It's simply different.
And if I may, Ms. Corrigan, as I'm reading the trial court's order, did the trial court concluded in the manner of finding jurisdiction on the basis that you're dealing with a Florida attorney, a licensed Florida attorney, and the fact that, yes, they were trying to solicit clients from Florida, even though there, based on my record here, it doesn't appear that there were any clients in Florida. And what the court did conclude that by virtue of that relationship, of that partnership, that all the money that was generated for the partnership was attributable to the fact that you had a licensed Florida lawyer. Did I read that correctly?
I think the court focused a lot on Mr. Wilder's status as a Florida lawyer, but I think what was overlooked by the court was that the work involved here, like I said, doesn't necessarily require a Florida lawyer. And all of the work that he had done in Florida, and the court's decision actually restates some of that he had represented clients in Florida for all these years. All of that predates what happened in this case. Mr. Wilder left Florida in 2017 and has been in Texas ever since. So it's not like he was servicing all of those Florida clients during the time period that's relevant here. Here, the parties were only involved in their business arrangement from early 2021 through January of 2022. And Mr. Wilder was not in Florida at that time.
And so the court's conclusion, you're taking issue with the fact that there were clients here in Florida. You take issue with that there's really no basis in the record for that determination.
There were no clients in Florida. And
because
even though Mr. Wilder testified that he did attempt to solicit some in Florida, that was via Zoom phone calls, and there were no actual Florida clients.
And any money that was generated, any pecuniary gain that the partnership realized, was there anything coming from Florida towards those gains?
No, absolutely not.
So, and in terms of the analysis, in terms of the connexity, based on the Capella case, the Capella case was kind of unique in the sense that it's a joint venture. There's really no entity that has a business in Florida, but came to the conclusion because of the infusion of all the money, because of that investment, because of all of that joint venture in a Florida company, that was sufficient to subject it to jurisdiction by the court. So with that backdrop, in this case, we're trying to determine, was there any type of pecuniary gain, any type of influx of any clients in Florida, any monies generated as a result of any connection with Florida? That's what I'm trying to look at based on the facts of this case to subject it to the personal jurisdiction?
And the answer is categorically no. There were no Florida clients. There was no revenue generated from Florida. And in the RJPT case, LSI was a functioning company. It had offices. It was actually, working. It was, the Laser Spine Institute. It was a big business in Florida. Here, Wildflower was simply filed its articles of organization in Florida, and that's it. It wasn't a functioning, operating business out of Florida.
Ms. Corrigan, you are at your 5-minute mark. Use the minutes as you please.
I'll save it for rebuttal. Thank you.
Okay, great. All right, Mr. Long, you're up.
Thank you, Judge. Tom Long, may it please the court. I'm representing Wildflower Legacy and Wealth Planning, the plaintiff and appellee in this matter. As stated by the trial court, after 2 separate hearings, the last one being an evidentiary hearing where everybody testified, all the principals, the evidence was overwhelming that there was a general partnership between the defendants and Wildflower, a Florida company. That partnership was formed for the specific purpose of pursuing a business venture that had its result of trying to obtain pecuniary gain. Under Vernon and Kelly, if a non-resident partner, if a partnership is subject to Florida jurisdiction, which Wildflower clearly is, it's a Florida company. If the partnership is subject to Florida jurisdiction, the non-resident partners, by virtue of agency and mutual obligations, are also subject to Florida jurisdiction based upon the partnership, because they are partners, they are mutually obligated, and they are mutually subject to jurisdiction. That law under Kelly and Vernon is clear, and this was a partner.
Mr. Long, my issue with Kelly, the reliance on Kelly and Vernon, is that in Kelly, the partnership had offices in Florida, as well as there was in Vernon, the non-residents were conducting business in Florida through some of their partners. And I think the non-residents were also working on an estate that was being probated in Florida. And so in each of those cases, the facts turn, I realize what the holding says, but we also need to look at the facts, and those facts aren't present in our case because we don't have, and I know offices aren't required, but we don't have those additional connectivity to Florida here.
Judge, I understand your concern, but I think you're reading those cases too narrowly. What they said is, remember, neither one of the entities, Touche Ross or the New York law firm, neither one of those entities were Florida entities. In this case, the partner is a Florida entity that is subject to jurisdiction. And what those cases say is that if you are in a partnership with an entity, with your partner is a Florida entity subject to jurisdiction, you're subject to jurisdiction also. Those cases don't say you need anything other than you need to be a partner with an entity that has Florida jurisdiction. And as a result of that Florida jurisdiction, you're also subject to jurisdiction because you're their partner. And that basically, the other cases actually are harder cases because they had to find a basis other than the fact that they were Florida entities to get the jurisdiction. Here, you have jurisdiction carte blanche because Wildflower is a Florida entity subject to Florida jurisdiction. And once you're a partner, and the court went through, there is a factual dispute concerning whether they're partners or not. The defendants really stretched, as the court stated, strained credibility. In their solicitations, both defendants signed solicitations stating, we, the group, a joint venture comprised of.
Could we also, and I appreciate that, could we also find though that the partnership was equally a Texas partnership as opposed to a Florida partnership?
Judge, you have a Florida, you have a Florida entity, indisputably a Florida entity that is subject.
Is a partner with each of the other two non-residents.
And there, judges, there may be jurisdiction in Texas. But the issue before this court is the trial judge heard all the arguments, all the facts, and determined that jurisdiction lied properly in Florida. And because there's a Florida entity that is clearly subject to jurisdiction, there's clearly a partnership between the three entities. Whether you call that partnership Florida partnership or Texas partnership, it doesn't really matter because jurisdiction is in Florida by virtue of the partnership. I assume that if Texas had the same law, there would be jurisdiction in Texas, but that doesn't deny that there's jurisdiction in Florida.
So if I understand your argument, Mr. Long, I apologize, Judge Smith. If I understand your arguments wrong, you're saying simply by virtue of the partnership relationship between the three entities, because we have a Florida corporate, like for better word, Florida corporation, that you don't need to look beyond anything more, whether connectivity, nothing at all, by virtue of it being a Florida corporation, that it is subject to the jurisdiction of the court.
It's subject to Florida long-arm jurisdiction, Your Honor. Then under Capella, you have to go into whether you have the minimum contacts, then you got to go to the connectivity. I recognize that the minimum contacts.
Okay. Okay, and then, so let's jump then. Okay, let's just assume for the sake that we agree there's a partnership, we agree it's a Florida corporation. Let's just jump to this connexity argument. How, in this transcript, where is it that the court made a determination that there was some sort of connexity in Florida?
Well, I think the court basically it knew Capella, it went through the Capella factors and determined that, as the trial court stated, that the parties' collective ability to earn revenue turned in large part on the provision of tax and legal advice contributed by Wildflower. And the connectivity, if you look at the solicitations and the engagement letters, they tout Florida, Wildflower is a Florida CPA firm. They tout that Wilder is a Florida lawyer giving tax and legal advice and protective of the attorney-client privilege. So, and the whole point of the lawsuit is that the partnership was wrongfully terminated by the defendants because they essentially saw, once they got the secret sauce and got all the information, how to file these employee retention credits with the IRS, they said, why do we need Wilder? So the connectivity with these defendants is that they solicited using the Florida corporation, the Florida lawyer. They agreed I would say they consented to jurisdiction in Florida and consented to it when they had the terms and conditions. They stated that any dispute between the partnership and the client would be arbitrated in either Florida or Texas at Wilder's option, which means that.
And I appreciate all that, Ms. Ron, but I'm just trying to determine based on this record, even taking everything that you're saying is absolutely appropriate. What's the connect? Was there any pecuniary gain coming out of Florida? Were there any clients? I know there was, some people were being solicited. Nothing came out of that. Was there anything that would tie it to Florida in terms of letters of engagement, letters of, representation, things that would appear that there's activity going on in Florida?
Well, Your Honor, again, I would just point out that the master service agreement, which is, exhibit number 55 in the, basically talks all about Wilder legacy and wealth planning is a licensed CPA firm in Florida, wholly owned by Greg Wilder. Wilder is also a licensed attorney in the state of Florida, and all technical conclusions and work product will be subject to all applicable attorney-client privilege based upon his status as a Florida lawyer. There's Florida all over the place. In the terms and conditions, it says arbitration. Let's arbitrate at Wilder's discretion in Florida. So the other partners, by virtue of the partnership status, are consenting to that Florida jurisdiction. So the connectivity is there by virtue of the whole solicitation process, the whole marketing process, the whole agreement process that prominently displays and talks about Florida. And
Mr. Long, let me, so do any of the acts that are complained about in the complaint and that were, through the testimony at the limited evidentiary hearing, we have the games, we have a Gator game, and then we have a meeting with Mr. Pierre at Capitol Grill and Mr. Wilder. Is there anything that arises out of those meetings that form the basis of either the breach of contract action or the breach of fiduciary action?
Judge, I think it would be clear that what I was saying in terms of what the breaches were is that once they got the secret sauce, they figured, well, we need this. What do we need this guy for? Okay, so all those were instrumental in letting the defendants know how it worked, what Wilder was bringing to the table, what he brought to the table, and therefore they're all interrelated. It's not like is there a specific incident? No, but it certainly was a combination of Florida connections, Florida exhortations, Florida promotional materials, and in the end, Florida agreements.
I get my question is, in reading the cases, it seems to me with the connexity that there has to be something, that connection between the defendant's acts in Florida that give rise to this cause of action. And I understand what you're saying in a general sense, that all of these amounted to what, in the end, they breached by terminating because they've got the secret sauce and they got everything they need to do it on their own. And I understand that. But I'm trying to see if we need to focus on the actual activities and what gave rise to the cause of actions that are alleged based on those activities in Florida. And maybe I'm too narrowly focused on that, but anyway, I wanted you to help me out there.
Judge, I think you're too narrowly focused on it. That's because I think you have to look at the whole part of what the jurisdictional was basis. And in large part, it rests upon the fact that you agreed to be a partner with a Florida attorney, with a Florida CPA term, touted that, marketed that, engaged, told the clients that, said that you'd arbitrate in Florida, that the entire, remember, this is during the pandemic, everybody's virtual at this point. So there isn't any specific incident in Florida, except that you agreed. And I think under the cases under Kelly and Vernon, if you are a partner with a Florida partnership or a partner that is subject to jurisdiction in Florida, you're subject to jurisdiction too, because you're working together, and they were. And so I don't think I think you're reading it too narrowly. You need, something to happen in Florida. This is a virtual operation, 17 different states that there are clients from all over the country. It has to be litigated somewhere. And the defendants agreed to become partners with a Florida company, knowingly, and promoted that company. And the judge heard the...
Yeah, and so basically, Mr. Long, I think I guess it boils down to the following. And for lack of a better word, selling a Florida attorney service, whether that for purposes of connectivity to Florida, that basically, and with him being and part of the agreement and that because he's a partner, he's a Florida corporation, and if you agree that there's a partnership, they're all in it together, selling his, touting to the fact you have a Florida lawyer, that I think in your term is sufficient for connexity to Florida to be subjected to a lawsuit.
Yes, ma'am, because you deliberately chosen to partner with an entity that you know is subject to Florida jurisdiction, and you know you are a partner with that entity. And that entity is a national entity. It's during the pandemic, and the entity does work all over the place, seeking to do work in Florida, soliciting clients in Florida, and
by virtue and because there was no fruition as a result of the solicitation, your argument is by virtue of the solicitation alone for Florida clients, that is sufficient for that connectivity to Florida.
Not just that, Judge, but also the promotional materials and that which they tout in their engagement letters, that it's Florida attorney and Florida CPA firm. You get special, as they said in their engagement letters, we got an attorney-client privilege, which some of these folks would probably want to have because we got a Florida attorney as one of our partners. So again, you have to look at it like the trial judge, comprehensively and not narrowly. And if you look at the cases that talk about if you're a partnership with a Florida entity that's subject to Florida jurisdiction, well, you know what? You're a partner, you're subject to Florida jurisdiction too. And I don't know if I'm running out of time. I just would like to.
You have 4 minutes left, Mr. Long.
Well, if there's any other questions, but I wanted to make sure that this judge, a 16-page order that went to great length. This was not written by Tom Law. It had nothing to do with this order. He heard all this evidence. He heard these guys testify, these defendants, who both testified that their relationship was a, quote, loose collaboration. This is in the face of the fact that they sent solicitations to client stating in the first sentence, we, the joint venture of these people, where they sent memos that terminated the general partnership, carefully written, reviewed by their lawyer, sent to referral sources, terminating the partnership, and they said, no, that was still a loose collaboration. And the judge found that strained credibility. And I know that two of you, Your Honors, are ex-trial judges, you know a euphemism when you see one. There's somebody who testifies under oath, untruthfully, to gain an advantage in a proceeding. And I think if you look at the totality of the circumstances as a connection to Florida, as what they did to Florida, in a trial court's determination, that this is one that frankly should be summarily affirmed. And that, unless there's other questions, sums up my argument.
Thank you, Mr. Long. Okay, Ms. Corrigan, you're up to rebut.
Ms. Corrigan, can I just jump in? Because that was my question of Mr. Long. By virtue of the fact that you're dealing with a for lack of a better word, selling a Florida attorney service, you have that in the record. You have evidence of solicitation, promotional activity. Do you still need to have a pecuniary gain? Do you still need to have some sort of action happening in Florida for it to be connected to Florida? Or is that sufficient for purposes to be subjected to the jurisdiction of the court by virtue of it being a Florida company, solicitation was done, promotional activity? Is that sufficient to do that?
I don't think that solicitation enough is sufficient. The connexity requires a causal connection between the defendant's activities in Florida and the plaintiff's cause of action. And we simply don't have that here. The partnership could be decided that it's a Texas partnership because its principal place of business at the time the parties worked together was in Texas and not Florida. What Mr. Wilder brought to the table, the secret sauce, so to speak, he brought it from Texas, not Florida. There was no money derived from Florida. There were 50 clients that they served from 15 different states, but none was from Florida. So there were no Florida clients and there was no Florida revenue. None of the acts that Wildflower is complaining about actually occurred in Florida. The money that is claimed to be owed was not generated from Florida clients. It's from other states. And the case law does not support that solicitation alone is sufficient to establish Florida jurisdiction. The fact that the company was originally formed in Florida should not be enough that years later, when it's no longer even operating in Florida, it should not be permitted to bind out-of-state defendants who did not, their only participation is the fact that Wildflower was formed in Florida. But as we put it out in our briefs, even Wildflower wasn't actually operating in Florida. It was operating out of Texas. That's where it received its mail. That's where it had a Chase Bank account that was originally open in Florida, but the money was sent to the branch in Texas.
And Ms. Corrigan, and the part in the final judgment where the court made a definitive ruling that there was some activities that Mr. Wilder did perform, for lack of better, services in Florida. How do you respond, to that?
Even Mr. Wilder admitted when he testified at the evidentiary hearing that he never went to Florida for the purposes of doing the work on these ERC arrangements. He was in Florida at times. He was there for Thanksgiving. He was there for Florida CLE credits, and he did work remotely. Brought his laptop with him, and he did testify he did do work in Florida. But he himself admitted he never went to Florida solely for the basis of doing this work.
And my next question, maybe this is more, I'm just trying to understand the defamation. One of the actions was defamation, that your clients supposedly defamed, saying, he doesn't know, basically he doesn't know what he's talking about. He provides, bad advice. Do you think by virtue of the fact that did these other entities, these 19 others that were based elsewhere, that they went ahead and hired these partners by virtue of the fact that he is a Florida lawyer? That, let me put it this way. Is the fact that these other entities they ended up agreeing to these services, that they were convinced that they needed to participate in this by virtue of the fact that you have a Florida licensed lawyer? Do you think that goes into the equation?
I don't think there's any evidence. There certainly was not at the evidentiary hearing about what those clients were looking for. The fact that Mr. Wilder was a lawyer, I believe, was important. The fact that he was a Florida lawyer, I don't believe is important for the purposes of this analysis. It was a federal tax credit. This wasn't some peculiar Florida program or something that they were doing that involved specifically Florida law. This was a federal tax program. It required a lawyer, but it didn't require a Florida lawyer.
Okay, Ms. Corrigan, you and Judge Kazam have used your rebuttal time.
Oh, I apologize, Ms. Corrigan. I peppered you as well as I peppered Mr. Long, but thank you both.
Thank you both very much. In order to leave our virtual courtroom, you should click, or must click, the leave button in the lower right-hand corner of your Zoom screen, and you'll head off into the ether.
Thank you.
Thank you very much, judges. Thank you.
you.